Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi ta'ala wabarakatuh. Today's topic is the theory of akad or contract. So as a human beings, we need to interact and do muamalat with each other. So it is through the business transactions and muamalat that human beings fulfill their needs. We need goods and services to survive. We need goods and services to satisfy our needs. So cooperation or muamalat can take various forms, and in Islam it involves certain akad, or in English, contract. What's the meaning of contract? In Arabic, it's called akad. The word akad, literally, lughatan, akad means to join or to tie together, to combine or to bind, mengikat. It connotes the meaning of conjunction, as it joins, it binds the elements of disposition, namely ijab and qabul. Ijab is the offer, and qabul is the acceptance. So in akad, there is sirah. There is an element of sirah which consists of the offer, ijab, and qabul, the acceptance. So akad also means fulfillment, agreement, and determination. Istilahan, technically, akad or contract refers to an agreement between two persons, which is legally binding and which has consequences upon the subject of contract. The subject of contract means the goods and or services involved in the akad. According to Hashim Ma'ruf al-Usaini, akad is an agreement, and the consequence is an obligation and binding upon the contracting parties. Dr. Muhammad Taha Mansuri mentions that the term akad is used in two senses, in general and in specific senses. In the general sense, akad is applied to every act in general, which is undertaken in sincerity and with firm determination, regardless of the different nature of the contract, whether the contract is unilateral or bilateral. On the other hand, in its specific meaning, akad or contract is confined to only bilateral, means there are two parties. Because akad is defined as a combination of offer, ijab, and acceptance, qabul. So there are two parties involved, for example, purchaser and seller. As a result of the akad, there is a certain legal consequences. In Murshid al-Hayran, in Murshid al-Hayran, the term akad is defined as conjunction of an offer emanating from one of the two contracting parties with the acceptance of the other in a manner that it affects the subject matter of the contract. And the Majil defines akad as what the parties bind themselves and undertake to do with reference to a particular matter. It is affected by the combination of offer and acceptance. Al-Inayah defines akad as legal relationship created by the conjunction of two declarations, ijab and qabul, from which flow legal consequences with regard to the subject matter. So in Islam, the permissibility or legality of akad is derived from the Quran and the Sunnah. There are a number of verses in the Quran, and also there are a number of Sunnah which regulates the principles of akad, and there are different terms used such as akad, mithaq, ahad, and wa'ad. Allah subhanahu wa ta'ala mentions in the Quran, O you who believe, fulfill all contracts. Lawful for you are the animals of grazing livestock, except for that which is recited to you in this Quran. Hunting not being permitted while you are in the state of ihram. Indeed, Allah ordains what He intends. In the Sunnah, Rasulullah sallallahu alaihi wasallam reminded the Sahaba and all the followers to fulfill and sustain the akad obligations. In one hadith, Abu Hurairah reported that Rasulullah sallallahu alaihi wasallam was saying there are three signs of a hypocrite. When he speaks, he lies. When he makes a promise, he breaks it. And when he is trusted, he breaches his contract. He breaches his trust. So in this hadith, Rasulullah sallallahu alaihi wasallam emphasizes that the promise must be fulfilled. Therefore, the contract is more binding than the promise, which must be fulfilled. Now let's discuss the essential elements and conditions of a valid contract. The contract does not have to be in a formal way. There are four types of contract. Number one is by oral. Number two, by writing. Number three, by behavior. And number four, by signs or gesture. So the contract doesn't have to be in writing. And it can be informal akad. So in a contract, all that is required is the declaration of consent or sirah by each party. The Majlis mentions that the conclusion of a contract consists of connecting offer, ijab, and acceptance, qabul, together legally in such a manner that results may be perfectly clear. According to Madhab Hanafi, there is only one pillar of a valid contract, that is sirah. As long as there is offer and acceptance, the aqad is considered as valid. So according to Madhab Hanafi, the parties to the contract or the subject matter of a contract are not the pillars of the contract. So the buyer and seller is not part of the contract. It's not the pillar of the contract. The subject matter also is not the pillar of contract. So the Hanafis argue that only sirah, offer and acceptance, necessarily include and imply the existence of parties and of the subject matter. So according to the Hanafis, if there is sirah, there must be two parties and there must be a subject matter. So sirah is enough according to the Hanafis. However, the majority of Muslim jurists, Jumhur ulama, argue that there are three essential elements or pillars or arkanul aqad. Number one, sirah, the offer and acceptance. Number two, aqidan, the two contracting parties, the seller and the buyer. And number three, the subject matter, ma'qud alayh. The subject matter means the goods or services to be purchased and sold. So the first pillar, arkan, is sirah, which consists of offer and acceptance. So sirah is important in the formation of aqad to ensure the contracting parties, the seller and buyer, really understand, agree, and conclude the contract consciously with a sound mind. In fact, mutual consent of the parties is the basis for the formation of an aqad. Buka lampu belakang, Ustaz. Allah says in the Quran, O you who believe, eat not up your property among yourselves in vanity, but let there be among you trade by mutual consent. Sirah al-Aqdu is defined as the manifestation of the will of the contracting parties that indicate clearly their intention to contract. This will or intention is manifested through several medium of expression. So the medium of expression doesn't have to be formal. It can be in writing, formally, or it can be an oral agreement, or just a gesture, or the conduct or behavior. So there is no such a formality in expressing consent in the formation of contract. The offer, ijab, and acceptance, qabul, can be made by utterance, by saying the word orally, or conduct, or in writing, or also in gesture or signs for people who cannot speak, or even if they can speak, um, the sirah can also take the form of gesture according to some jurists. For nonverbal manifestation of consent, the Malikis are of the view that anything that is customarily regarded as indicative of consent could be used. So sometimes it can be non-verbal, for example, gesture or signs uh, is also accepted according to the Malikis. According to the Hanafis, consent may also be inferred from a written offer and acceptance, from conduct and even gestures. To the Shafi'is, the only valid way to express consent is through spoken words. What is an offer? An offer is an indication or expression of willingness to become bounded by some obligation if another party accepts the offer. According to the Majel, offer or ijab is the statement made in the first place with a view to making a disposition of property, and such disposition is proved thereby. So that is the definition of ijab according to the Majel. Ijab or offer is a statement made in the first place with a view to making a disposition of property, and such disposition is proved thereby. For example, one person wants to sell a house, so he made an offer or ijab. For example, he says, I sell this house to you for 200,000 ringgit. So that is called offer or ijab. On the other hand, an acceptance or qabul means an act whereby a party agrees to the offer, terms, or offer made to him. For example, the buyer says, I, I buy the house for 200,000 ringgit. So that is the acceptance or the qabul, which shows that he agrees to the offer made by the seller. According to the Majel, qabul or acceptance is defined as the statement made in the second place with a view to making a disposition of property. The contract becomes completed thereby. Therefore, as long as the communication of offer and acceptance is done properly and understood by the contracting parties, the akad or contract is considered valid and concluded, and the akad has its legal effect. Arkan, the second pillar of akad. The second pillar of akad is aqidan, the contracting parties. The akad, in order to be valid, must be concluded by a qualified and a competent person. The seller and the buyer must be uh, qualified and competent. The contracting parties are required to possess necessary legal capacity or ahliyah. Some jurists define ahliyah or legal capacity as the ability or the fitness to acquire rights and exercise them and to accept duties and perform them. There are two types of legal capacity, namely capacity for acquisition of rights, ahliyah al-wujub, and capacity for execution of rights, ahliyah al-ada. So number one, ahliyah al-wujub, capacity for acquisition of rights, and ahliyah al-ada, capacity for execution of rights. Capacity for acquisition of rights or ahliyah al-wujub refers to the capacity of a person to receive rights and responsibility due to him. All humans who are alive possess this capacity. Even the baby or fetus in the womb of his or her mother possess this capacity through incomplete, although it is incomplete. Ahliyah al-wujub an-naqisa. Capacity for execution of rights. Ahliyah al-ada, on the other hand, refers to the eligibility of a person to execute or to discharge his rights and duties in a manner recognized by the law. The principal elements of Ahliyah al-Ada, the capacity for execution of rights. are the intellectual standard that the person has attained. He has to have the sound mind and the ability to distinguish between useful and harmful, profitable or unprofitable. He has to be aqil and mumayyiz. Aqil means the capacity, the sound mind or the intellectual standard, and also mumayyiz means the ability to distinguish between useful and harmful. So that is ahliyatul ada, the capacity for execution of right. So for a person to be qualified to participate in an akad, he must possess capacity for execution. Ahliyatul ada. Ahliyatul ada, capacity of execution, there are two types. One is ahliyatul ada an-naqisah, incomplete capacity, refers to the eligibility of a person to perform some duties only, but he cannot perform all the duties. This eligibility begins from the age of 7 to the age of puberty. However, the jurists differ on their opinions as regard to this issue. According to the Hanafis, if a person has attained the stage of discernment or mumayyiz, his positions are divided into three categories. Number one, transactions are purely for own benefit, such as acceptance of a gift. These are allowed for a person who has attained puberty, baligh, but who can discriminate and has been permitted by his guardian to exercise such acceptance. So if the person attains the age of puberty and he is baligh, so um, he has qualified uh, to perform a certain akad or a certain duty, sorry, but not all. So according to Hanafis also, if the person has attained the age of puberty and he is baligh and mumayyiz, um, purely something that is purely harmful for him, such as giving, his contract is void even with the permission or consent of his guardian. If um, it is purely harmful for him, then the contract is not valid. If if it is harmful for him. Number three, possibly for his or against his benefits, such as sale, In this case, the contract is valid if permission of a guardian is obtained. So in the third case, there is a possibility that the sale is beneficial or the sale is harmful. So if a person, for example, is baligh and mumayyiz, for example, he's 10 years old, he's baligh and mumayyiz, can he perform the sale? So if according to the Hanafis, if there is a possibility that the sale might bring benefit and also might bring harm, then he should consult the guardian, whether the parents or any other guardians. So according to the Hanafis, it depends. If it is beneficial, then it is allowed. For those who are baligh and mumayyiz, for example, a 10-year-old or 11 or 12-year-old boy or girl, if it is beneficial, then it is permitted and the akad is valid. If it is harmful, then the akad is not valid. And if there is a possibility of being beneficial as well as possibility of being harmful, then the permission of the guardian is required in order to be valid. That is according to the Hanafis. On the other hand, the Shafi'is and the Hanbalis rule that the transactions entered by a person under this category are void because he is considered unqualified to become a party in the contract. And then the second type is ahliyatul ada al-kamila. Complete capacity of execution refers to the eligibility of a person to exercise his rights and undertake obligations in a manner recognized by law without being subjected to any other person's approval. This stage of legal capacity is established when a person has reached the age of puberty and attained prudence. Prudence means the ability to make decisions and to manage his or her property. Now let's talk about the hindrance, hijab. There are certain hindrances to legal capacity. There are certain factors which impair the legal capacity of a person and prevent him from concluding contracts and making dispositions in his property. These legal hindrances can be divided into two, awarid samawiyah and awarid muktasabah. Awarid samawiyah, heavenly defect or natural defects, any defect which is beyond a person's power or defect in which no intervention from man but are given by God, such as junoon, insanity, idiocy, etc. And number two, awarid muktasabah. Awarid muktasabah means acquired defects which are within a person's power and acquired by the act of the man himself, such as sukur, being drunk or intoxicated, iflas, being muflis or being bankrupt. That is called awarid muktasabah. And the third pillar of an aqad is the subject matter of the contract or the goods and services to be transacted. There are several conditions for the subject matter, maqud alay. Number one, maqud alay or the subject matter must be in existence. It must exist. The subject matter must exist at the time of the aqad. It is not allowed to sell a subject matter which is yet to be in existence because it involves the element of uncertainty and excessive risk, which is forbidden in Islam. This is based on the hadith, sell not what you do not have. Sell not what you do not have. And in another hadith of the Prophet sallallahu alaihi wasallam, uh, the Prophet sallallahu alaihi wasallam said, prohibiting the sale of the unborn animal in the womb of its mother. So this hadith prohibits the sale of the unborn animal in the womb of its mother. Therefore, the sale of the animal fetus which is not yet born, whilst the mother is not part of the sale, is prohibited. And the sale of milk, whilst it is still within the udder of animals, are also prohibited. However, some jurists differ in their opinion whether this condition applies to every kind of contract or to certain contracts only and not the others. The Hanafis and Shafi'is maintain that this rule should be applicable to every contract. That is according to the Hanafis and Shafi'is. However, the Malikis apply this rule only to the contract of exchange, uqud al-muwa'adah, uqudul mu'awadah, the contract of exchange, where there is consideration from the other party to the contract. Hence, this rule is not applicable to gratuitous contract, uqud at-tabarru'ah, uqud at-tabarru'ah. So it can be done even though the subject matter are not in existence yet, such as contract of gift, charity, and waqf. Ibn Qayyum and Ibn Taymiyyah, on the other hand, do not consider the existence of subject matter as a condition of contract. So according to Ibn Taymiyyah and Ibn Qayyum, the subject matter does not have to be in existence. This rule is applicable in the contract of sale as they permit the sale of items, goods, or services that do not exist at the time of the aqad if their future existence is known according to custom. They disallow only the sale that constitute gharar or directly forbidden by the legal texts such as Al-Quran and As-Sunnah. However, there are certain contracts accepted. However, there are certain akad or contracts accepted, although they may not fulfill this condition, though the reasons for allowing them are varied. Some scholars cite the doctrine of istihsan as the reason, while some mention the reason of need or haja and or necessity, darura, as the reason for allowing the non-existence of the subject matter at the time of the akad. These contracts are similar to Ba'ul Salam, Ba'ul Istisna, and Ijara. These are the types of contracts where the subject matter maqud alayh are not in existence at the time of the akad. Inshallah, we'll talk more about Ba'ul Salam, Ba'ul Istisna, and Ijara. Deliverability of the subject matter. So, the subject matter of the akad, maqud alayh, must be able to be delivered. And it is very important that the subject matter can be delivered. Otherwise, the contract is not valid. The Muslim jurists therefore forbid the sale of stray animals. For example, the sale of birds still flying in the sky, or the sale of fish still swimming in the ocean and not being caught yet. So the Muslim jurists forbid the sale of stray animals whose whereabouts are not known, or fish in the sea, or birds in the sky, etc. And let's talk about the precise determination of the subject matter. The subject matter ma'qud alayh must be precisely determined in terms of its essence, quantity, and value, and specification, to the extent that the knowledge is sufficient to avoid future disputes. And legality of subject matter. The subject matter to be ma'qud alayh, to be included in the akad, must be something which is legally permissible. The contract is considered invalid if the subject matter is something that is acquired unlawfully. For example, stolen items, or has no commercial value according to Sharia, such as pig, wine, and an-najasat, things that are um, an-najasat, uh, things that are, I don't know how to translate. Haram items, an-najasat, najis, alcohol. These are items which have no commercial value and therefore is forbidden by the Sharia to be considered as ma'qud alayh. So it is forbidden for a Muslim to acquire or transfer through contract anything that Sharia has declared as haram. The validity of contract also requires that the object and the underlying cause must be legal. In other words, the intended objectives of the contract must not be contrary to any Islamic principles. A contract made for the use of a property in commission in doing the offense when the parties know this fact is unlawful. For example, the sale of a gun to a thief when the seller knows that the gun is going to be used for purpose of stealing, of for the purpose of rompakan. The gun is used to rob a bank, for example. Then the sale of the gun is unlawful.
Understand?
Yes.
Uh, how about free gift? If we want to sell it, it is possible to be maqbul alaih.
Oh, you mean okay?
Yeah,
Someone someone gave to you a gift
freely. Yeah, free.
for free. So you get the gift for free. Then
Yeah,
you want to sell the gift.
yeah.
Okay. Why you want to sell the gift? Okay,
It
never
is
mind.
possible.
Yeah, yeah,
Maybe something has no value for us, but we
yeah.
want to sell
Understand.
for others.
Under, understand.
Yeah,
So,
yeah.
so
How about
the gift is under your ownership as a perfect ownership. So therefore, it can be used as maqud alay if it is
okay?
in existence and within your ownership as a complete ownership. Yes, you can sell the gift.
Okay.
Termination of contract. So the last topic about akad is the termination of the akad. A contract or akad could be discharged or terminated in the following situations. Number one, by performance or ada. Once a contract is concluded by offer, by an offer and acceptance of the parties to the contract is binding upon both the seller and the buyer. The obligations under the contract extend until the subject matter of the promise is respectively performed. Once the performance of the parties' task takes place, the obligation no longer remains, and therefore the contract is terminated. For example, in the contract of Wakala, the contract is terminated once the agent performs the act which he was given the task to do through the contract of agency. In this case, the agent's obligation is discharged when he has successfully completed the task given by the principal. So that is the termination of the akad by performance. For example, one person A, he appoints another person B to be the wakil or the agent to perform certain tasks. Once the second person, person B, performed the task completely, then the akad is done. So the akad has been completely done. Therefore, the akad is terminated after the task is performed. Number two, the akad is terminated also by express agreement or iqala. Iqala means termination of contract by mutual agreement. The Majel defined iqala as to annul or to cancel a contract and put an end to it. A party cannot unilaterally terminate the akad or contract, as the contract is a right of both the of, of, of both the contracting parties. However, if both parties agree to terminate the contract after its conclusion, it is valid because of their mutual agreement and mutual satisfaction. Number three, akad can also be terminated by impossibility of performance. Istihala at-tanfid. The akad or contract may be terminated by circumstances which render performance impossible. It's impossible to perform, or at least so different from that contemplated that it would not be reasonable to hold the parties bound by the contract. Article 443 of the Major provides that if any events occurred whereby the underlying reason for the conclusion of the contract disappears so that the contract cannot be performed, such contract is rescinded or cancelled. And the contract can be terminated also by breach of contract, naqdul aqd. Breach of contract is an unjustifiable refusal or failure by one party to a lawful and enforceable contract to implement any of the duties incumbent on him under the contract. The parties in a valid contract have no option to breach any terms or conditions made by them, and if there is a breach of contract, there is also relief for the innocent against the wrongdoer, so the fairness and justice would be upheld among the parties to the contract. So if any one of the party breach the akad or the contract as agreed, then the contract is terminated.
Betul. by
Yes.
the breach of the contract, nakat of nak al-akad. You mean mutual agreement that one of the two parties maybe disagree for subject matter. Can can we breach the contract? For example, when they doing the transaction to buy a car, and then the the seller uh, actually cannot tell the truth about the condition of the car. This is they consider the breach of the contract.
Yes, exactly. So breach of contracts mean one of the parties refuse or fail uh, to implement the contract as agreed. For example, he promised to sell a Mercedes, right? Mercedes manufactured in year 2010, and then as it turns out, the Mercedes was manufactured, for example, in year 2005. So that is also just an example of breach of contract. He failed or he refused to implement or to deliver the goods as promised. So the seller in this case has the right to terminate the contract, and the contract or akad is terminated because of the breach of contract. Did I answer your question or not?
Yeah, yeah. Okay, correct. I,
So did I answer your question?
yes, okay, yes.
Okay, good. Because sometimes the line is not very clear. And number 5, the akad or contract is terminated by expiration of the contract period. So the expiry of the contract period will cause its termination. For example, in the case of renting a house for 1 year, so after 1 year, then the akad is terminated. Some of the contracts are entered into by the parties for a certain period of time. Once the period expires, the contract will be automatically terminated. And number 6, the contract is terminated in case of the death of the contracting parties. Death of the parties can be the cause of the termination of certain contracts according to some jurists. For example, according to the Hanafis, the death of any one of the contracting parties will terminate the contract of ijara.
Doctor,
Yes,
I want to explain about the debt of the contracting
sure.
ijarah, the debt of the contracting parties.
Yes, please.
In Bank Islam, we have the Mastercard.
Okay.
Mastercard. Okay, Mastercard actually, when we compare with the conventional bank and Islamic bank, when the customer, actually the person use the Mastercard, even they use around 3,000, 4,000 buy something, some good or whatever, you spend the Mastercard. And then when the card holder, I mean the Mastercard, debt, We have the actually the contract of two party uh, maybe uh, uh, fail lah because maybe they have the contract actually they break the contract, and then the bank Islam they have the insurance to cover back the the some of the money when the person die use lah. And then
Yeah.
we compare
It's
let's say we
takaful. There's
yeah,
takaful.
takaful. And then this that's why Islamic they concerned about the contracting party of that because when somebody use the conventional card after that the actually the wife or the person who live must pay the actually the balance of the credit card. That's why in Islamic bank we have Bank Rakyat and Bank Islam. We have to start actually whatever use the person use the card when they die, so they have the takaful.
Yes. Yes. So in the akad of Mastercard uh, credit card, for example, um, the particulars of the akad includes the case of the death of the card holder, and in case uh, in the case of the death of the card holder, takaful will come in and ensure that it will pay on behalf of the deceased. So in this case, the takaful takes over uh, as some sort of guarantor or the insurer in the case of the death. So in that case, it is not the termination of the contract in that case. So death of the contracting parties can be the cause of the termination of certain contract in certain cases only. But in the case that you mentioned, death of contracting parties does not terminate the contract. In the case of Bank Islam, uh, it does not terminate the contract because takaful will come in and pay on behalf of the deceased.
Oh, I see.
If the death of the contracting parties cause the termination of the contract, in that case, oh mati lah bank ya. Who's going to pay, right? That's
Yeah,
why
yeah.
the bank requires that the contracting party, which is the customer, take takaful as to ensure against the death.
Oh, I see.
So it doesn't cause the termination of the akad because someone else, the other party, takes over.
It mean the contract is continue.
Yes, continue in the sense that somebody else will take over and pay on his or her behalf.
Oh, okay, thank you.
Termination means, in certain cases, it terminates. Means there is no obligation to pay. In certain cases, but in the case of that you mentioned, it, the death of the contracting parties does not cause the termination. So the point is, sometimes the death of contracting parties cause the termination of contract, but in practical, the banks must be very smart to ensure that the death does not cause the termination of the contract. Otherwise, the bank would be in trouble.
Then will be bankrupt.
Just like personal financing or home financing. For example, if you apply home financing, you are also required to buy takafu. Two types of takafu. One is to insure against the death, and the other one is to insure against the damage of the property.
Yeah,
So
correct.
by home financing, the death of the contracting parties does not cause the termination of the contract because Takafu will take over as the guarantor for the contracting party.
You mean the doctor when they takaful pay to the actually house they clear of the outstanding balance in the bank. So after that, so the contract is terminated.
Yes, yes, exactly. Yes. After the Takafu make the full settlement, then the akad is terminated. Hmm. But the akad is not terminated in home financing after the death of the customer because
That's why it's important to buy a takaful, no,
it
for
is actually
the
required.
buyer.
The customer
Oh,
has no choice.
Yeah.
So
oh,
they must buy two types of takaful. One is to insure against death, and two to insure against the damage to the property and against calamity.
Doctor, how about the overseas? The financing of
The what?
overseas, the bank of the maybe for um, my my fleet out what Camat. They have the actually in Egypt they have the financing. They I said they also has the takafu for their financing housing.
Ahmad, in Egypt, do you have takaful for financing, home financing or personal financing? Are you required to take takaful? Where is Ahmad? Mukri,
yeah.
do you know anything about that in some other Muslim countries, Egypt, Pakistan, or any other Muslim countries? Uh,
Should apply that.
I will have to check, but I think the banks are smart enough to make sure that the customer take the takaful. Otherwise, the bank would be in trouble if the death of the customer caused the termination.
That's right. Yeah, correct.
So, for example, if the death of customer means the termination, it means the customer has the akad is void and there is no obligation to pay on behalf of the customer to the bank.
Sometimes the bank smart doctor they
Yeah,
they
They
sell
actually
all
doing business. They actually doing business, right?
yeah, they
yes,
sell everything actually, and then they what the balance of the housing, and then they pay to the the person who related with the that.
yes. The banks are smart. Even uh, some other financial institutions like the government who give home financing, they are also very smart. Um, Even for public servants who apply for home financing, they are still required to take takaful. So even the government is smart.
Oh, the government they advise to take like a takaful for the
Not
government
advice,
loan.
they require.
Required.
Wajib.
Uh,
The,
uh,
the customer has no option. They need to buy two types of takaful also. So
The concept of the damage is same, same.
uh, the concept of the damage is kind of different. Um, the damage is when the damage or calamity occurs uh, to the maqud alay. For example, the house. If the house is damaged, then the seller of the house uh, is not obligated to make the compensation to the house buyer. Instead, takaful will come in and pay for the damage. So that constitutes a different type of contract.
Takaful as per rental.
Yes, to insure
Okay,
against the damage.
okay, clear.
In this case, the developer is smart. For example, you buy the house, and your house is damaged after 1 year. Suppose there is a damage to the house after 1 year. If the damage is covered by takaful, then the developer doesn't have to pay the compensation. It is a takaful who will pay the compensation.
Dia tak masuk bawah kategori zalim kan macam tu.
We will discuss in the topic of takaful. Dia dia tak dipanggil zalim, dia dipanggil good financial planning.
Jadi developer lah untung macam tu.
Dia panggil good and sound financial planning dia panggil. Dia tak panggil zalim.
tapi doktor developer selalunya dia give the period macam kata kalau baru beli lah rumah tu kan.
Selalu setahun lah,
okay.
1 tahun.
Setahun lah tu lah. Tapi kalau selepas tu memang pelanggan lah yang customer tu yang kena tanggung kan.
Tapi
kata dia zalim lah.
dia panggil dalam istilah finance dia panggil sound Islamic financial planning. Istilah dia kan.
Sound Islamic financial planning.
IFP, Islamic financial planning. Dia dalam tajuk IFP, Islamic financial planning. So the developer is smart. After 1 year, the developer is not obligated to pay any compensation. So anything, the buyer will deal with the takaful. And the buyer needs to pay for the takaful. Itu yang Mukri kata macam zalim tu.
Doktor, actually kalau kita nak tanya sikit, kalau kita beli rumah kan, kontrak kita beli rumah dengan developer. So developer tu dia cakap harga rumah tu dalam 200,000. Tapi tapi dia ada unsur penipuan lah dari segi bata, dia tak guna bata merah, dalam spesifik tu dia guna bata merah, ada di kategori dalam ni lah white contract lah kalau
tapi in reality it's very difficult to to terminate the contract, disebabkan benda-benda yang kecil, although dari segi legally the contract can be terminated, but in reality it's not as easy as that. Sebagai contoh kan, dia beli rumah 2 tingkat. Dalam, ni contoh je lah, dalam spesifikasi dia, tingkap aluminium. Lepas tu, bila dia beli, tengok-tengok tingkap kayu. Contohlah.
Betul.
So dia boleh terminate kontrak. Tapi bila dia terminate kontrak, mungkin dia akan rasa, alah,
Mungkin ya.
sikit je ni kan. Sikit je masalah kan. So, kadang-kadang dia rasa benda yang defect tu terlampau kecil lah. So dia decide untuk continue lah. Sebab dia dah buat loan. Jadi bila buat loan, nak terminate loan tu is more costly than the defect. So the defect, in order to be terminated, the defect must be proven. Bila kita beli rumah, dia akan specify tingkap jenis apa. So ada seorang kawan saya tu, dia tak puas hati dengan tingkap rumah dia. Dia tengok tingkap rumah dia buat benda kayu. So dia faham, zaman sekarang tingkap mesti buat benda aluminium kan. So bila dia buka balik kontrak, the contract states that the window is of solid material. Dia tak cakap wood ke aluminium ke. So sometimes developer is very smart. Sebelum dia nak buat tu, dia dah tengok spesifikasi kan. Tu contoh lah. So dalam kes tu, developer menang.
Sebab ayat tak jelas lah. Ayat tu kontrak tu lah.
Fahaman buyer tu saja kan. Dia kata aluminium. Tapi perkataan aluminium tak ditulis. Kita bila beli rumah, kita bukan nak baca benda-benda gitu kan.
Betul. Betul. Apa yang kita cakap tu betul. Sometimes dia betul lah. Kita sign saja lah. Tengok dia okey semua kan. Tengok kan. Dia tak baca kontrak tu kadang. Tapi dalam Islam, kita macam kalau kita sign kontrak tanpa memahami dasar-dasar kontrak itu adalah adakah dia sebagai macam dapat pahala ke apa? Tanya tu.
Kalau kita sign tanpa membaca, salahnya customer tu lah. Customer tu yang salah. Tapi selalu kita tak baca. Tapi sebenarnya kita mesti baca. Kalau kita enter into any contract or akad, it is an obligation or our duty to read before we sign. Tapi masalah kita kan dalam reality lah, when we enter into any contract, home financing, personal financing, kita nak senang, kita tak baca, kita pergi sign je.
Banyak page doktor, ada 12 page, 18 page, satu page. Memang selalunya saya tengok customer yang sign tu pun macam dia orang buat apa tawaruk kan, kalau dia orang buat apa personal financing kan. Dia orang salah, maybe dia orang study dekat rumah kan, tapi selalunya dia orang sign, dia sign. So dia tak tahu lah sama ada after dia orang sign kontrak tu and then dia balik rumah dia baca kontrak tu. Saya tak pasti kan, tapi tu selalunya customer datang dia orang mesti sign. Okay, sini sign di sini. Dia tak baca. Cuma akad untuk tawaruk tu macam kontrak kan, dia ada satu pembelian tawaruk lah, macam beli metal daripada London lah, harga berapa and then bayar balik berapa, itu tawaruk lah dekat bank. Kadang dia orang design dia.
Dalam realiti, kebanyakan customer sign saja. Dia tak baca. Maybe banker or officer tu brief dia sikit lah.
Maybe dia beri action sikit lah.
So dia sign je. Kemudian tu, macam kes tawaruk, selalunya bank tak bagi sijil pembelian metal atau
Betul.
komoditi tu. Tapi kalau ikut SAC, Syariah Advisory Council of Bank Negara Malaysia, the customer has the right to ask for the proof of purchase of the commodity. Dia sebenarnya bank boleh provide dia panggil proof of purchase of the commodity. Dia macam satu certificate.
Tapi dalam tu dah ada dah. Memang ada nampak dia punya certificate dia orang dia beli tu. Nanti saya kena tarik balik dekat saya punya bank tengok dia punya apa. Dia saya buka balik file tengok apa ada. Dia proof tu certificate tu. Maksud dia kita kena bagi tahu kat pelanggan yang dah sign ni, maksud dia ada meter apa semua skim tawaruk lah tu.
Ya, isu yang banyak dibincang di seminar ialah betulkah berlaku the sale and purchase of the commodity dekat for example commodity metal kan, the metal commodity, betulkah berlaku? Itu yang
Tapi doktor, saya pernah check dalam sistem kan. Memang kita ada dia punya kat situ, dia punya time dia. Tapi pasti sebab ini HQ yang dia orang arrange apa semua. Bila macam customer apply personal financing apa semua, dia ada satu tempat tu bila macam dah approve dah. So kadang-kadang dia hantar melalui WhatsApp ke ataupun ni saya cakap okay, you punya ni dah approve. So ada certain bank yang mana just bagi tahu kata okey akad dah agree melalui handphone lah, sama ada you agree tak agree. Kita agree, kita yes, maksud dia terjadi akad. Ada some bank lah saya tengok tak pasti ada member kita adakah dia tertakluk pada akad tawaruk. Maybe dah setuju, kita setuju dah melalui SMS semua. Mungkin yang dah beli tu pun
Ya, jadi isu yang timbul ialah ada orang persoal, betulkah transaksi tu berlaku? So jawapannya sebenarnya transaksi tu memang berlaku. Pembelian komoditi metal semua tu dia ada spesifik dia bila, masa, di mana, memang berlaku. Cuma ada setengah scholars lah, dia kata kenapa bank tak provide certificate kepada customer untuk elakkan
okay ke doktor kalau macam kita dah setuju dah, kita agree kan, yes. Lepas tu after that dia orang macam bank tu kena SMS satu contract note tu dekat customer
dia panggil certificate. Dia macam satu certificate kan. So actually the bank is obligated to do the transaction. Kalau transaction tu tak berlaku dan SAC, Syariah Advisory Council, kalau dia ada masa-masa dia akan pergi audit di bank kan, dan
betul tak mendapat
kalau dia minta dan benda tu tak wujud kan, dia dah tak comply dan akan diambil tindakan. So bank sebenarnya tak ada choice, dia memang akan buat.
Tapi takut juga doktor kalau tak wujud apa kontrak ni, takut dia jadi riba doktor
Ya
dia
memang
jadi kalau dia punya kalau tak betul mendapati tawaruk ni tu
dia jadi deception lah, penipuan lah kan.
Penipuan Kalau penipuan tu dia ada wujud unsur riba lah tu doktor. Kalau kata dah white contract tu untuk financingnya, tapi dia jadi loan lah, itu ada wujud itu lah.
Yang pasti dia dipanggil penipuan lah, maksudnya transaction yang tapi bank tak akan menipu sebab dia akan diaudit oleh bank negara. Itu bukan isu. Transaction tu memang berlaku sebab bank negara monitor kan, mana bank berani ambil risiko kan. Cuma isunya yang dipersoal, kenapa bank tak isu kepada every customer? Bank cuma isu kepada customer who request the certificate. Adalah customer tu kalau dia lecturer ke, dia orang yang nak tahu benda tu betul-betul berlaku puas hati, dia boleh dia request kepada bank. Kalau guna tawaruk tu, maknanya mana bukti sertifikat kata pembelian komoditi itu berlaku. Bank boleh provide. Cuma kebanyakan customer tak peduli sangat lah kan. Dia assume benda tu berlaku lah.
Betul. Bila cikgu-cikgu yang sign agreement tu, jadi dia orang duit masuk, dia orang sign dia. Dia hantar check sama ada dia komoditi apa semua tu. Jadi bertanya bila masuk. Itu standard lah betul.
So pihak bank pun jawab macam tu lah. Dia kata customer tak request. So itu je. Benda tu memang berlaku lah. Otherwise bank tak akan berani ambil risiko kan, dikenakan tindakan oleh bank negara kan.
Betul.
Okey. So insya-Allah kita akan sambung tajuk our next topic ialah berkaitan dengan tajuk apa tu? Kontrak dalam bentuk al-bai', dalam bentuk jual beli. So our next topic, let's see. So our next topic will be a sale contract. Kontrak melibatkan jualan.
InsyaAllah.
So I will share the books afterwards, and I advise you to start writing your assignment. So your assignment contains 3 parts: the introduction to the concept, and then the modus operandi. You need to write a diagram on how the contract should be implemented. And the most important thing is the third part, whether Islamic financial institutions in Malaysia use that concept in the offering of product. For example, al-istisna. The concept of istisna is used in which type of product? So you can ask me any questions about the assignment, and after you finish the first assignment, there'll be a second assignment. So, wallahu ta'ala a'lam.